Commission was squashed by the court. As it is right now, the position that was taken in 1970 stands. And item of interest, Honorable Chair, is that there is no vacant land in Moyoya Education Section and in that area. All the land there is titled, and there are private individuals sitting on that land with existing titles. So I think it is important for the committee to know that.
Honorable Masala.
Thank you, Chair. Chair, the PS gave an answer which is not accurate. For somebody to be evicted in land, it's not the provincial administration. They must start with the Minister of Lands, because they must certify that the land is owned by who, and then the due process must be done. The Minister of Interior are the final, they just implement a ruling which is done by the relevant or organs of the government. Somebody without documentation. So to me, for we to solve this problem, first, did the ministry ascertain the compensation or the money paid by this community to the colonial for the 20 acres? Two, if it was done, when the demarcation was being done in 1976, was there involvement of this same community? And when these people were being evicted in 1989, who caused the action for them? Because somebody cannot just come and evict. There must be somebody who petitioned or requested for eviction of a specific people. I hope you have this document, because if these people were in this land from 1950 to 1989, the Republic of Kenyan Lands Law indicated that when you stay in a land for over 13 years, even if that land is not yours, you have an interest. If I'm wrong, the PS can tell me. So if these people were in this land from 1950 to 1989, how many years are those? Those are over 39 years of existing in a land. Nobody challenging them. Now, can we know who caused the eviction, the orders, who gave them, and then if these people paid for the 20 acre of land to the colonial in 1950s, then this land belongs to them.
Yeah, so, you had attempted to answer that question, and I would request that you once again try to react to that question.
Honorable Chair, it is true that if you stay in a private land, as per the law of advanced possession, for more than 12 years, you can go to court and claim for advanced possession. I am not aware if there is any claim if there was any claim by the said people that went to court for advanced possession. The land does not belong to you when you sit for 20 years in someone's land if you don't go to court and the court awards you through advanced possession. So I think it is erroneous what the Honourable Member is saying, that although these people might have stayed for more than 13 years, I don't think there is any claim that this community went to court on advanced possession and they are awarded. In the absence of that, then it is not applicable in the sense that you cannot just stay in a land and it becomes yours. There are processes that ought to be done. Having said that, Honourable Chair, we are not aware of any payment to the colonial government. We have not been provided with any receipts or proof of payment by the petitioners. We are not aware of the eviction as claimed by the petitioners. If there was any eviction that was done, then it is not an eviction that was sanctioned by the State of Department, or it was not documented that we have documents to show that there was an eviction done. If there was an eviction that was done that was made as prescribed by the petitioners, it is unfortunate, but we are not aware as a State Department. So I cannot confirm or deny that there was an eviction or there is no eviction that happened on the issue.
Honourable Senator.
Chair, I'm getting confused. And the reason is because the State Department works very closely with the NLC. The PS has said that there was a decision by NLC, which was challenged in court, and that decision had a basis. And I think that if I'm not wrong, that decision was based on Gazette Notice BOL CXXI number 207 of 2019, March 2019. In that Gazette Notice, the NLC awarded the Tende community, which forms one of the petitioners, the 20 acres of land. You did award. It means that there was a basis for which that award was done, including what you are saying that there was no eviction in 1989. Surely, there was a basis for which you made that determination. In fact, about that determination, it goes without saying that what would follow if there was not that court decision that the PS alluded to, it was the issuance of titles on the 20,000 acres or out of the condition of the 60,000. So I'm confused here. What I wanted to know is the PS, if an LC awarded the Tende community based on that Gazette Notice, the land of 20 acres, what made it impossible to issue titles to the Tende community that encompass the Korea community? That's why we have to start. So that we see if there was a court decision to stop that, was there a further appeal by NLC based on the basis for which you awarded that piece of land?
So maybe of interest here, PS, I heard you say that NLC, the decision by NLC was later quashed in court. Maybe it's good to know, since that was done this year, February 2025, why is it that from 2019, when LC investigated the historical injustice and granted the 20,000 acres, why is it that there was no action from the Ministry of Lands between then and or when perhaps was the case registered, or rather an appeal made by the interested parties?
I just wanted to see whether it's not the PS has presented to you the judgment.
Yes.
And when you look at the face of the judgment, the case reads that it was filed constitutional petition of 2019. So the matter was of 2019 and therefore decided from 2025.
Can we request for copies of the ruling?
I sent myself to the clerk so that it will be circulated to the committee. So I think they can be given a soft copy.
Do you have enough copies of this ruling? Yeah.
That was my position. And the member correctly says it was not appealed.
Do you have a copy of the ruling?
Yes, I have. And I wanted to ask a question so that the PS can answer all of it together. Because in light of what the Honorable Senator has asked, so that we can all have a clear picture. I wanted to ask.
You have a copy of the ruling and the PS has this.
And I have sent it to the committee on a soft copy. So I didn't want to undertake the cost of that increasing it. Because I was not to be hard anyway on this issue. And if you allow Mr. Chairman, I would be more useful as a head of the committee to ask this question.
Okay.
So that, so I wanted to know whether the PS understands that, first of all, the jurisdiction of the High Court is higher than that of the NLC. And that the two grounds under which the court pushed the NLC, one which is very important was that the Maasai people, the Syria community living in Moyoi, were not heard in the NLC.
that at no point did they appear at the NLC, and therefore the court said even all these things that my honorable colleague from Sunai West is saying have not been determined to be a fact because our side was not heard. That is one of the reasons why this thing was pushed. And the second one, when you look at page 39 of that judgment, it says in 353, it therefore goes without saying that the determination of the first respondent, who is the NLC, on the 7th of February 2019, was arrived at without lawful claim or complaint of historical land injustice having been admitted, and any proceedings undertaken thereafter were in contravention of Article 47, 48, 50, and 232 of the Constitution. So, any claim on historical claim was never determined. So, these are stories, bedtime stories we are hearing. The court says there was no historical claim. There was no appeal by the so-called tender community or by anybody else. So even the petition is listening to a story. The case is finished.
Yes.
Yes, Chair. After the determination by the NLC in 2019, this case was filed in 2019. So we couldn't proceed because we had orders to implement the determination of the National Land Commission. Until now, the ruling was rendered this year. So, Honorable Chair, that is the reason why we couldn't proceed in implementing the NLC decision. So, so I think that was the question, Honorable Chair.
Yes. So, is that now clear?
Sorry, Honorable Chair, just for clarity. I did not say, for the record, that there was no eviction. I said we are not aware if there was eviction or no eviction, asking for eviction. Because we have no records, Honorable Chair.
Chair, it was the issue I raised. If you allow me.
Yes, yes.
Chair, I think that answer is still not accurate because the Ministry of Land is an interested party here. If there was a claim that in 1989 there was eviction and these things were registered, well, you can't tell us you are not aware because you are an interested party and you work with the Ministry of Interior. You need to know because land documentation belongs to you. If you say you are not aware and it was registered way back in 1989, this case has been in existence from 2019 to date. You are still not aware. It means you are not interested to know.
Honorable Chair, that is not factual, Honorable Chair. The eviction done are not registered in the registry. Even the evictions done today, Honorable Chair, we are not aware of evictions done today. If the court was to order an eviction in Mombasa, there is no way that there is a requirement that that eviction is.
Kindly wait a bit. The NLC is here, isn't it? Yes. So please, for the record, please introduce yourselves. So that, yeah. And I take notice that there is also a member who was coming, so you will, the NLC will introduce themselves after. Please introduce yourself, Machine.
Thank you, Chair. I'm Matthias Robbie, LB West. I got an invitation for this petition, and I'm late because of the communication. The letter I received was reading 11:30. Then later, I talked to Moshinat Kayama and told me that time had been changed. I was in a meeting on budget at 8:00. So, can I say something while I wait the introduction?
Wait until they introduce themselves.
Thank you, Honorable Chair and members. My name is Brian Ecole, and the CEO is on the way. She kindly requests your indulgence. She's a bit late, but the Secretariat is here.
Thank you, and good morning, Honorable Chair and members. My name is Samuel Tuni, Director in charge of Land Administration and National Commission. Good morning, Honorable Chair and members. My name is Justin Maro, Communication Officer.
Good morning, Honorable Chair and members. My name is Jades Osi, Communication Officer, National Land Commission.
morning, Honorable Chair and members. My name is Faruq Yombia, Senior Planning Officer.
All right. And I believe this is the CEO. Madam CEO, kindly introduce yourself.
Thank you, Honorable Chair and members. My name is Kabale Kochi, CEO National Land Commission. Sorry for coming in late. I was actually attending to address a distressed client in the office. Thank you.
All right, thank you. So, yes, Honorable Senator.
Chair, there's a question that I had that fundamentally wasn't responded to. And I still go back to the intervention of National Land Commission, which informs the decision of the State Department. The decision had been made by the National Land Commission that awarded the 20 acres to the Tene or rather the Kuria community. I was in that space when this court determination was brought into the equation. The court determination does not question the people of Kuria on their rights of land. The court determination questions the action of NLC on two accounts. One, whether there was fair hearing between the National Land Commission and the involved parties that will look at the other people who are on the other side. Okay? So, and then the second, if you read the determination here, the court says there needs to be a permanent injunction on all titles of ownership. If you look at 357, which means that even the petitioners who question the NLC ought to have their title ought to be suspended until NLC goes and sees with both parties. The conclusion of the court, 357, if you have got the petition. Yeah, a declaration be and is hereby made squashing the first respondent termination under claim and a claim known as that Gazette notice. I don't want to read the entire part of there. Interested parties to cancel and or revoke all ownership documents issued in Angata Baragoi adjudication sections and Mayoi adjudication sections. Meaning that there is an action that has not been taken by NLC to be able to farm the Gazette notice as seen by the court. So what I'm expecting here is one, NLC should actually
Mr. Chairman, sorry, in a point of order, let the Senator read the thing for the truthful presentation. Let him just read the whole.
Why, Honorable Sumpuli, why don't you allow him to make his submission in full, and then you can interject. What is out of order?
Let him read so that you understand.
To either petition the decision of the court made here, or take action as the pronouncement of the court here. Those are the only two solutions. Because the decision of the court is not to squash the entire ownership of the people of Kuria, the land. The decision of the court is questioning two things. Was there a fair hearing in the determination that informed the notice that was given that awarded the Tende community the land? If there was none, then the decision of the court says suspend all titles until that determination is made. And the only way to make that determination is for NLC to take responsibility to either petition to the higher court or to take action on the further hearing that involves the two communities. And that has not been done. That's what I'm saying.
Yes.
That is not factual, Honorable Chair. Honorable Chair, the National Land Commission made a determination. And in that determination, it is true that the National Land Commission made a determination in favor of the Tende community. Immediately that determination was done, Angata Baragoi Farmers Cooperative Society Limited and others moved to court to challenge the decision by the National Land Commission. The courts made the determination and based one of the bases that the Angata Baragoi and other parties who own the titles to that land, that the National Land Commission made a determination in favor of historical injustice for the Kenya people. The court, one of the bases that the Angata farmers went to court was on the basis that this determination was made when God listened to us. As the owners of the title, we already have the title of that land. And the court made a determination saying, in fact, in 343 says, if such proceedings did happen, which the court highly doubts, the petitioners herein, all the persons who have been affected, who are lawful registered landowners of Angata Baragoy Adjudication Section and Moyo Adjudication Section, were never notified of any claim or complaint of historical land injustice, and were never given an opportunity to be heard before the first respondent made the recommendation to cancel and revoke their ownership documents. It further goes in conclusion to say, Honorable Chair, that in 357B, a declaration be and is hereby made quashing the first respondent determination under the claim of historical land injustice number 19 of 27, pronounced on 7 February 2019 and published in Gazette number 1550, dated 1st March 2019, recommending first and second interested parties to cancel and revoke the documents of America. That is the first determination. The second one, which the Honorable Chair is reading in half, is a permanent injunction. B is hereby issued prohibiting first to third respondent interested parties from implementing the quashed determination by the first respondent in the proceeding referred as MLC/HLI 19/2019 in regards to the petitioner's ownership documents and generally all titles issued in Angata Baragoy Education Section and Moyo Education Section. This is in regards to the HLI decision, all titles issued in regards to this HLI, not for the entire education section, Honorable Chair, just for the interpretation of this decision, Honorable Chair. So, Honorable Chair, and it is important to note that among the people who were taken to court by the case, Honorable Chair, is actually Munyonge and Haki as an independent, as an interested party. So this decision made by the court, the Munyonge and Haki, who petitioned Parliament, cannot run away from it, Honorable Chair, because they were in court as an interested party when this decision was made. They have not challenged this decision in the Court of Appeal, Honorable Chair, but they have come to Parliament instead of challenging this decision at the Court of Appeal, Honorable Chair.
Chair. Is the PS trying to say that?
No one has given you the floor. Who would want to say something? Let us have the Honorable Mark and then the Honorable Marius.
Chair, allow me to just take the committee back a little, and including the PS and my colleagues. You know, this is a very, very sensitive matter because the people being affected are represented by the petitioner. The people who are defending are also represented by a friend of the committee, including all of us who are all here, the political class, including my senator and my other colleagues. I just wanted to ask that even as we submit that we consider that this matter is affecting the lives of Kenyans who are not necessarily our voters, that we should try and speak to this matter considering our guys from the Moyoi community who are the Maasais and the other communities that live around there, irrespective of whether we represent them or not. Because otherwise then, Chair, the committee might descend into everyone trying to defend the people that they actually represent, which is also their right, but to try and resolve it. But my question to the PS, and he's actually right, that the ministry does not keep a register of evictions, whether they happen or not. But PS, sitting where you sit, and then they'll see where you sit, representing Kenyans. Doesn't the government have the machinery? Because we're talking about the government, we're not talking about the Ministry of Lands. We're not talking about your specific Department of Lands. And when you are here as a PS, you're actually representing the government in whole. Doesn't the government have the machinery to determine whether the evictions did happen or not happen? You having the records notwithstanding. That would be the question. If someone came to your office and told you that they have actually been forcefully evicted, he's saying that we do not have a record of such eviction sufficient, according to you, without consulting your larger government arm to find out whether such evictions really did happen. And my answer would be that it is incumbent upon you PS to find out, even from the Ministry of Interior. The government has machinery to the ground. Because the Ministry of Lands, the government, I don't want to talk about Ministry of Lands, because you're here representing the government. If you speak to the Ministry of Interior, and in their report, they will tell you that that eviction did happen. So it is actually wrong for the PS representing government in this session to say that he doesn't have the records. Whereas he's a PS of a section or whatever, but he has, it is up to him to find out from other relevant government agencies, did an eviction happen? And I'm sure if he did that, he will be able to essentially find. Number two, Chair, on this matter, when you look at it, NLC, and that is now my next question. When you make a determination as NLC to try and bring people to where they actually were, and maybe your decision is actually challenged, representing Kenyans who sometimes are ignorant of the law or who don't know what their next step is, because when people have come here for petition, we cannot now start saying, oh, they should have challenged it in court and things like that. The reason why this committee actually was set up is to try and help Kenyans. Many of them who come to us don't even know the procedures of what essentially needs to happen. So I'm asking NLC, when a determination that you're convinced was the right determination was done, and it has been challenged in court in a case where you are also participating, why is it that you people have also not appealed to defend your own decision? No. Order, my friend. Yeah, order.
You are making a lot of noise.
Yeah.
Yet I am here to give you an opportunity to speak when you need to.
Yeah. So when NLC makes a determination, and the CEO is here, and it is challenged in court, your determination is actually made in court. You are also government, and you think you made the right decision. At what point do you consider it necessary as a commission to also appeal on your judgment? Thank you, Chair.
Honorable Marius.
Thank you, Chair. Chairman, we met here for this petition, and I'm happy that today we are here again. The CEO of National Land Commission is here, PS for Lands is here, and many people are here watching. Chairman, when I entered here, I found the PS speaking, and he said it clear that they don't deal with historical land, it is NLC. And Chairman, if it is NLC which deals with historical land, and I can say it here again, 2019, NLC did their due diligence following extensive hearings and awarded that land of 20 acres to people of Korea. Chairman, it is very bitter when you see people dying on the same land, people of Korea being evicted from the same land. When you were here, you can remember one of them standing here and said he was shot 8 times. And still on that land. Just recently, When today I hear PS saying that he's not aware of any religion on that land, I get shocked. I can tell you, after that petition we were here, many people from Korea again have died in the top record. Many have been injured in the same land. Scripture said people have titles. Can you find out when these people got those titles? It is after, with the influence. Because he's here, as whatever Yamita said, representing government. We are serving in the same government. Sometimes we get shocked. In the government we belong, today, our people suffering. It's very bitter. Chairman, I decided to come here because I serve people of Korea who today, if sometimes you watch, you can sympathize. We have talked to the president to sort this. Personally, I've talked to the CS of Interior many times. I've talked to the Inspector General, sympathize with the people of Korea to go and sort this matter. I've talked to the PS who is in front here. We have met in his office, and even one time I went with the retirement and we said, see how you can sort this matter. People of Korea keep this can live in peace if this government decides to intervene and solve this matter. But you see, when we raise these complaints to be sorted, nobody hears. But we find that one side is being favored, being supported by policemen who authorized to go and assist to evict people from that land. And I can tell you today here, we are all human beings. It's good that the CEO of National Land Commission today, she's here. The PS is here. People of Korea are suffering in this government, under hands of government we are serving. If the truth is to be followed, who owns that land? People of Korea are the owner of that land. And if NLC made a decision and later on things changed, you can't tell what happened again. So the CEO of National Land Commission is here. I know she has a report to tell us here, but what we are praying is that let us sort this matter and the people of Korea get their land. Thank you, Chair.
The National Land Commission, what do you have to say about the issues raised? And not forgetting the issue that was raised by the Bonapies, the issue raised by the Honorable Mark Namita is an issue that you will need also to respond to. But let's also allow Madam CEO to respond to the issues raised by the Honorable members.
Chair. Excuse me, Chair.
Do you have the responses with you?
Yes, Honorable Chair.
Have you shared them?
Yes, Honorable Chair.
Okay.
Honorable Chair.
Go ahead. Yes.
Yes, remember I said on our question number, I think that's the right time to change it.
Okay.
Chair, I wanted to know what the National Land Commission considered as historical injustice when they wanted to tender people 20,000 acres.
Let's allow her to respond first, and then if there are questions, we will ask or intervene.
Thank you, Honorable Chair and members.
Chair, we don't have copies of our response.
Do you have more copies with you? Please share. Proceed.
Thank you, Honorable Chair and members. Listening to PS submission, it's like he summarized my presentation this morning here. If you allow me, I can read through the written submission. Thank you, Honorable Chair.
Start on the response.
Yes, I think for the sake of honorable member who asked, what did you use as a measure to give the 20,000 acres? Allow me to read through the petitioner's claim. The petitioner's claims, represented by Munyonge and Anahaki, a welfare association of the Kuria people residing in Migori County, had raised concerns regarding their historical occupation and subsequent displacement from the area known as Moyoi, Escotula in Transmara, Narok County. They claim that the Kuria community are the original occupants of this land, with their presence predating the arrival of the Syrian Maasais in the 18th century. The petitioners assert that the Kuria people lawfully paid for the 20,000 acres of land in the 1950s, pursuant to the colonial era agreement, that these rights were found through historical documents, community testimonies, and court-supervised settlements. They said that on 2nd February 1989, the community was subjected to a forceful and violent eviction by the government, security agencies, resulting in the displacement of over 13,000 people, destructions of homes, loss of properties, and severe human rights violations. The petitioners further indicated that the National Land Commission considered the matter as historical land injustice, and after extensive hearings, issued Gazette Notice number 1550 of 1st March 2019, awarding the 20,000 acres to the Kuria people and recommended restitutions while integrating current occupants. The state, however, that the implementation of these recommendations has tolerantly due to the interfered by private developers and uncooperative local administrators. Those are the claims. They add that the continued impasse has undermined intercommunal peace along the Transmara border, and that unfounded allegations suggesting an intention to alter county boundaries have further inflamed tensions, despite the clarifications that they seek restitutions only. Not boundaries alteration. The petitioner said that the prolonged displacement has forced members of the community to live in informal settlements without adequate housing, access to land, or meaningful livelihood opportunities. This is in violation of Article 40, 43, 63, and 67 2A of the Constitutions. The petitioners therefore sought the intervention of the Public Petitions Committee to address their irregular acquisitions of land, to implement the NLC determinations issued in 2019 to cancel irregular titles, reserve the area, and facilitate purifications, settlement, and compensations of all affected Korean families. The petitioners began the community field a historical land injustice claim with the National Land Commission in the year 2017. The Commission received and admitted the claim and assigned it as historical land injustice claim under NLC dislocation land 01/2017. Our response to this, Honorable Chair, is that the Tenda community claim that they were evicted from their Agata Baragoi and Moyo Education Center in 1989, from where they have settled since 1945. After exchanging livestock with Syria clan of Maasai for land in an agreement witnessed by colonial government, that's Mararo Maasai Elder and Kono Kuya Elder, and the Narok DC then gave them a license to occupy the land. But after independence, the provincial administration bought their houses and evicted them in 1989. The area has since been adjudicated and registered as Angata Baragoi Balcoy and Moroi registration sections. The Commission proceeded to hear the claim under Article 67(2)(e) of the Constitution and Section 15 of the National Commission Act. The Commission also invited all parties for the hearing, but the response from the Chief Land Registrar, the Director of Land Education and Settlement from the Ministry of Land, and the Narrow County Commissioner did not appear. After hearing the parties, the Commission proceeded to issue a determination 7th February 2019, which was gazetted on 1st of March 2019. So that's how we arrived at the determinations. The Commission's measure was in the following terms. One is titles from the Key Education section of another of Paraguay Moyoi be revoked and are dedicated to accommodate all the communities, including the Tende community, especially on the part of the land that is unoccupied. The occupant, the claimant and the community need restitution as stipulated by NLC Act 12, Section 59 B to Area C, but with integration of the current land occupants. Looking at the court judgment, aggrieved by the decision of the Commission, the respondent here in Andata Barakoi farmers, 243 others, filed a court case, Narok AAC Petition 6 of 2021. And the court in its judgment, which was delivered on 27th of February 2025, ordered as follows. 1. Petition number 623, 2 and 3 of 2021 be merited. Environmental Affairs and Environment and Land Court at Kilgoris Environment and Land Decision number 8. A file, I think, with attached and annex under Register 1. Be a declaration be and by made quashing the first respondents' determinations under the claim known as NLC /HLI/019/2017, pronounced on 7th of February 2019 and published in the Kenya Gazette Notice of 1550 dated 1st of March 2019, recommending the first and the third interested party to cancel and revoke all ownership documents for Andata Barakoi Administration Section and Moya Administration Section. A permanent injunction be administered by year issued prohibiting the first and third interested parties from implementing the quashed determinations by the first respondent in the proceeding phrase as NLC/HLI/019/2017 in regards to the petitioners' ownership documents and generally all titles issued in Andata Barakoi Education Section and Moyo Education Section. 4. The petitioners in petition number 4 of 2021 violations regarding the fair hearing under Article 47, 48, and 50 of the Constitution. Each party, of course, to bear their cost. Honorable Chair, the National Land reiterates its earlier recommendations on the Kenya Community Historical Land and Justice, formally published under this 2019, and involved explicit court orders, including the quashing of the 2019 determination and the permanent injunction prohibiting the implementations of the Commission is bound by the order of the court. Honorable Chair, therefore the Commission remains fully committed in supporting the lawful redress of the historical land injustice across the country. Maybe you also make reference to Honorable Nyamita's comment, what NLC can do about this. We are only enjoying as an interested party in such case where we don't have explicit interest in the matter, because we have had the matter, we have determined, we have delivered our determinations, which has, however, been quashed by the court. So therefore, as my peers say, Akia and Mnoge and Haki, who are in court actually would have appealed them for the rest of us, ourselves and the ministry to be enjoined as interested parties. Secondly, if in the absence of us being enjoined in this case, because we did not file an outright appeal against the decision of the court, we are now open, and we want to thank the House, members of Parliament, for actually reviewing our NLC Act, Section 15, which has given us a continuous power to hear historical land injustice. So once the Commission is fully constituted, we are not fully constituted currently, then we will also ask them maybe to resubmit the claims for further review. Thank you, Madam Chair.
Thank you, Madam CEO. Now, on the issue of extensively listening to the stakeholders, did you listen to the, is it Moyo? Did you listen to Moyo?
Thank you, Honorable Chair. I think from the submission it's clear that the parties who are not present, which is largely on the administrator side, and our officers from the ministry, so probably in the absence of that, then the matter is not fully heard. And we have one of the members say that the administrator actually know who has benefited or not. Then in the absence of this, it may not be adequate information for us to make a decision on this. Probably there could be room for further review. Thank you.
So, how did you make a determination of a piece of land? When you said that you had a repetition as extensively, yet you did not go further and find out whether the land in question was occupied, or you did not seek to listen to those that were occupying the land, then can we really say that that matter was extensively dealt with?
Honorable Chair, I have Edmond Bishuru here, who is the head of historical land and justice. Before we make a decision, this is a technical team who visits the ground and advise the commission on what happened. Probably you are allowing to share the experience. Thank you.
Go ahead.
Thank you, Honorable.
Can you respond to this question?
Chair, I would want to ask NLC. They have mentioned that the parties did not come. Did you expressly invite both parties? 2, you mentioned that there was unoccupied land. That is where you based your determination to settle the historical injustices and give the Kuria people the 20,000 acres. Is that what you said? Thank you.
Go ahead.
Thank you, Honorable Chair and Vice Chair members. Whenever we actually take time, from 2017 to 2019, it's almost 2 years. And why we take time is we have to exhaust all the avenues. One of them is inviting the parties through a letter. Sometimes we even visit and have a stakeholder engagement on the ground. So, subject for me to confirm with my records, this has been done. But on the allocation of the land, I think it's explicitly indicated here that there was 20,000 which the community bought. So, likewise, given a time, I think if you can give me time, I can be able to confirm whether we have these 20,000 acres available or we based on the documents submitted by the Kuria community when they bought this land in the 80s. Thank you, Chair.
Let's allow that gentleman to submit first and then we come to more questions. What is it, Honorable Okesh?
Chair, there are 3 submissions that are very wanting, given that I've also been very involved in this Kuria issue. Chair, the CEO of the Commission has said that given the court determination, basically the Commission find is hands tied. They can't take any action. Chair, the court decision was on the determination of LLC. And LLC, constitutional, if you look at Article 253, incorporation of commissions and independent offices in Kenya, because there was even more authority than even state departments to run independently. It says each commission and each independent office is a body corporate with perpetual succession under seal. 2, is capable of suing and being sued in its corporate name. If a court has questioned your decision, why do you want to put this burden on the Kuria people to go back to court to appeal? It is your responsibility to go and defend that decision. That's number one. And I would wish that this particular committee makes a determination on that aspect of the Commission's lack of decision to actually engage the court on this matter. The second issue, Chair, is on what the Vice Chair has asked. The Vice Chair has asked whether all those other parties were invited. But actually, the Constitution gives the Commission the power of not only inviting, it gives the Commission power almost akin to the High Court of summoning, and I'm going to read it. Article 252 of the Constitution, General Functions and Powers of the Commission. It says, the following commissions and independent officers, and not given a lot of these commissions, there are only 4 that have been given have the power to issue a summon to a witness to assist for the purposes of its investigation. The number 1 commission is Kenya National Human Rights and Equality Commission, the Judicial Service Commission, and then the third one is the National Land Commission. So why is the commission giving burden to people of Kuria who are already overburdened by this issue? They don't have their lives going on. Why can't the commission do its job by issuing summons, concluding that investigation, and then challenging the court decision or its own decision? Chair, this is a question that must be answered.
Yes, Honorable Okech, your issues are very, very important and should actually must be answered, except that we would have waited for that gentleman to make his submission, and then you. Let's give the gentleman an opportunity to make submissions, and then your questions will be answered. Please go ahead. Mheshimiwa, kindly hold on.
Today you say I'm unreasonable. The first time I've been called that. But I wanted to ask you to be a bit fair to us, because we were dealing with that witness. And we wanted to ask questions on her, because she has said some things which means...
The witness you're talking about is the National Lands Commission. And the officer that we would want that he makes his a remark is from the National Lands Commission. So let him inform you more so that you will ask more questions. Yes, Honorable Vice Chair. Honorable Vice Chair.
Let me make this statement. I think if I heard right, the CEO requested his officer to assist her, give some information. So let's give them time, because it's the CEO that actually requested that that officer makes further submission on what she was trying to answer to the members. Thank you.
Yes, go ahead. And Madam CEO, please take note of the questions raised by the Honorable Senator.
Thank you, Chair and Honorable Members. The question by the Vice Honorable Chair on whether we invited all the parties. We did that as a matter of fact, and not once. We always invite parties for these hearings via written letters of invitation, and we use our county officers to reach out to the parties. We also call these parties for purposes of these proceedings, and so they were invited, but unfortunately, if you look at the determination of the Commission, there was a finding that despite the invitation, they didn't participate. And again, the court was able to make a finding that, as a matter of fact, the Commission did not demonstrate that we invited all the parties. But to answer your question, yes, we do invite parties for hearing touching on historical land injustices. On the issue of unoccupied parcel of land that has been referred to in the decision or determination, one of the things we do, because this is an investigative process under the law, Section 15 of the NLC Act and Article 67(2)(e), we have to do ground visits. We send our technical officers, and they include an array of technical personnel, surveyors, land identificators. So personnel who have technical skills on settlement schemes and habilitation of parcels of land under the Land Habilitation Act. And they were able to establish that there's a portion of the land that is the subject of this dispute before the commission that was unoccupied, and that was the basis of the finding that was made by the commission. I think those were the two questions that Madam CEO requested I respond to. Thank you, Chair.
Yes, Honorable Sumbu.
Mr. Chair, I know you're a fair man, but you can see that there are very many people from the Godi here, and I'm the only one from Narok, so for heaven's sake, I will require a little more intervention because my class.
No, Chair, that is out of order. We are here representing the nation. We are not here representing respective counties.
I wish the comments would reflect that. But Mr. Chairman, I wanted to ask a question. Because the Honorable Senate has made a serious allegation that says you should rule over it. And please do. When you appear before an authority that is doing something akin to quasi-judicial, that is making a decision, like your committee now, like the NLC, that is a tribunal. Do you expect in the law of Kenya that tribunal will appeal against its own judgment? There are aggrieved parties that approached the NLC, and it was up to them to go to court if they were aggrieved. Secondly, and I want you to make the decision, actually we shouldn't be discussing about the decision of NLC here. It is moot. I wish there were some more lawyers here. The decision of the NLC has been taken to the court of competent authority and has been pushed. It doesn't exist, so to dig them again and ask them to explain to you how they did it. But now that you are there, let me ask them, Madam CEO, who were the commissioners of the NLC who had this dispute? And who are the technical officers who went to the ground? Is it true that this decision of NLC was influenced by a courier member who was there, and that there was nobody from Narok County or any part of Masai Land who was hearing the case? And is it true, therefore, that now that this case was never heard? Because cases are never heard by listening to one side. Because I was going to make in my submission a request to you, Mr. Chairman. It is clear you called the Tende community here without the Masai community. You had them in their absence. The NLC called called these other people without hearing them. Isn't it fair now that you actually rehear this matter?
The Honorable Sunkuli, when we called the Tende community here, we called them here because they were the petitioners.
So are you going to call the other side?
If they write to us to be heard, we will listen to them.
No, Mr. Chairman. But how are you as a committee going to to determine a petition, even if they don't apply? You have the powers to know, to say who are the other side.
The Honorable Sunkuli, we are in the process of doing a report and finding out exactly what is this petition about. So if there's going to be a need for us to listen to the other stakeholders, we are at liberty to invite them, or rather they are at liberty to write to us, and we will grant them an opportunity to be heard.
Or the other way.
But there was nothing, the Honorable Sunkuli, there was nothing wrong with us listening to the community, because they petitioned this committee, and it is our duty to listen to the petitioners when they do that.
All right, so how do you determine an issue like people's land being called empty land? Because, Mr. Chairman, let me say something so that I stop talking.
Okay.
Mr. Chairman, I would like to invite you to invite the people who live on the land. Number one. Number two, that I would like you to make a determination that this matter has been heard by a court of competent authority, and that this matter has been fully determined. Number three, in your invitation to me, you say that the purpose of this meeting is to reach consensus on measures to address the prayers sought by the petitioners and the insecurity in the region stemming from the land conflict. Mr. Chairman, unless the intention of this petition is to cause insecurity, there has been no insecurity between the Maasai Syria community and the Korea, not even cattle theft. So, this is untrue. Apart from the little problems we have had in Nyanderema between the Kipsigis and the Korea, which the Committee for Security has adequately addressed, the rest of the border, including Honorable Roby's place, has had no problem. So this issue is a very, very... Let me finish, Vice Chair.
Chair, is it right for the member to cast aspersions on the committee on the issue of security? We are here.
No, I think, Madam Chair.
Yes, Vice Chair. You are on the floor, Vice Chair. Continue.
Because it's not right for him to cast aspersions.
No.
We are here to listen. And also, Honorable Chair, the member should also realize that we invited him as a friend of this committee, and he should be able to listen, to have an hearing for everybody. We are a very fair committee, we need to listen to you, and when time comes, this petition was brought by the Korea people. Once we are done, and to the Speaker, they wrote to the Speaker, to Parliament, they petitioned Parliament, and Parliament, through the Speaker, gave this petition to this committee to listen to it. That is why we invited the petitioners to come and make their submission. At this moment, we are at the stakeholders. That is why we have invited NLC, that is why we have invited PS, that's why we have invited CS Interior to come as stakeholders. And we will also, at a time appropriate, if we need to invite the other party, or if they request, we will invite them as stakeholders and we will listen to them so that before we write our report. Thank you, Chair.
Chair, please, your hand up. Chair, just
Yes.
point of order, Mr. Speaker.
The Honorable Sunkuli was on the floor. Let him finish.
It is a point of order on his submission.
Yeah.
Point of order on his submission, Mr. Chair.
What is it?
Chair, there are two issues. One is claiming that people from Migori are many. Who stopped him from inviting people from Narok? Two is questioning the authority of NLC. The NLC is an established body with the authority to summon. When you summon you and you don't interfere, you don't appear. What next? Did he want them to arrest those people to come to them? Now, you invited people to come to this meeting. If somebody decides not to come, it is allowed in law to proceed because the NLC need just to provide us by evidence that they invited these other parties with through letters and whichever communication, and they didn't appear. And the right of these other, the Korean people, they were seeking their right. So they can't stop seeking their right because other people have decided not to appear.
I'm curious to know whether NLC has any evidence showing that they had invited the Moyoi people. Do you have any evidence?
Yes, Honorable Chair.
What evidence do you have?
We can provide the letters of invitation that we did. We did carry them with us today, but should you give us...
Were the letters acknowledged by the Moyoi?
So the service was... so in terms of acknowledgement, in terms of any written acknowledgement, no. But the delivery of the letters was done, or the invitation was actually done. But we're able to provide whatever evidence we have in terms of written documentation.
You know, you can have a letter of invite and keep it with you, and it doesn't find its way to the people who are supposed to receive it. So is there any evidence to show that indeed these people had been invited and it is only that they didn't show up?
Thank you, Chair. We did letters of invitation. I understand your concern on that. Ordinarily, what sometimes we do is we request for affidavit of service, so that the parties who we request to do the service. So sometimes the commission will order the claimants to serve the respondents. Where there is difficulty, the commission does the actual service. And what we do, we use our county offices to reach out to the parties in the county.
To whom did you address the letters of invite?
So what happens is when we receive a claim, we identify the respondents. So all respondents are invited for any proceedings touching on a claim that directly or indirectly affects them.
Chair, just for some point of
yes, the Honorable Sukulu, it's true he was on the floor.
Yeah, Mr. Chairman, I think the better answer is that the court anyway found that the others were not served. They were not invited. The court made that decision, and that has not been appealed against. And I was just saying, Mr. Chairman, I will request, if this request will be heard by you, that you hear this matter like a court should hear it. Just invite the other parties to come and listen, because even Adam and Eve were not condemned without hearing. You don't just invite the Maasai people, invite the Kipsigis people to come to this petition committee so that they can be heard. And you must also bear in mind the fact that the colonialists set up provincial boundaries, and that the true home of the Luo, the Kuria, and everybody is in Nyanza. Apart from those who have been given land in Osinoni, the rest actually belongs to Osinoni. So this commission should actually go and determine on the ground where are the boundaries between Nyanza and Rift Valley originally. Because, Mr. Chairman, it is also relevant for me to say that this is the
point of order, Chairman.
No, I want to finish. That's what the Chairman.
Point of order.
What is out of order?
Is the honorable member in order to say that if you come from Nyanza, you must own land in Nyanza?
Maybe
does it mean people of Kuria cannot own land on Rift Valley?
The Bible says that you should not covet other people's property.
Now,
and homelessness.
The Honorable Sunguli, the Honorable Matthias was on a point of order. I'm shocked that you decided to answer for me. Yeah, it was not for you to answer.
Today you're very hard on me, but
no, I'm being fair to you and to everyone.
Okay.
Yeah. So the Honorable Robbie had a point of order, and I think any Kenyan can have a piece of land, can own a piece of land in any part of the country.
Anyway, but the one that is being described is our land.
What is it, Honorable Engineer?
Is it fair for the friends of the committee, to attend this meeting?
That's a very good observation, that the friends of the committee are behaving as if they are not truly friends. So kindly make your submissions, finish and give other people a chance to make theirs in silence.
Mr. Chairman, I'm sorry, I'm not really a noisemaker normally. It's just that I'm finding myself in a situation where the procedure here.
You must restrain yourself henceforth.
Mr. Chairman, this is a very emotive issue. It is a petition which I would say is a bit mischievous but very dangerous. Because even you, as you sit as a committee of the National Assembly of Kenya, these famous stories that you want to send Kenya back to factory settings and say, where did everybody start from? Well, I would like you to invite you again. The NLC made the original mistake of hearing one side because of other reasons. Please don't make that mistake. Let us have another day, and let's have the tender back so that we can cross-examine them the way we have cross-examined these people. Then, you will, as a good judge, you will make a decision as whether there was any evictions, whether there was what we call ancestors living there, whether the land is empty, whether you will get these facts. But don't do it in the county hall. Come to the ground.
let's have this petition heard on the
NLC. Is it possible to hear this matter afresh?
No.
Honorable Chair and members, when this matter was determined, when the court quashed our position, we had a timeline of receiving historical and justice claim by September 2021. And I think the ruling, if I look at the ruling, it was in February 2025. Meaning we were not able to receive any claims by them. But now, as I've said earlier, His Excellency through His Excellency has approved, he has actually given us an extension of Section 15 of the National Commission Act through the wisdom of the Parliament. And we are not fully constituted currently. So once we are fully constituted, we can allow the members and the parties to submit the claims again, then relook at it.
Now, without you, I hereby protect UPS. Yes.
Because Chair, you invited me to make submissions on the factual position that we have, unless you want me to lie to you, Honorable Chair.
Yeah. And on that, I am in agreement with you, Honorable PS.
Chair, can you give me a...
Yes, Honorable Mark Nevita.
Chair, I think we are proceeding very well, and just one of your committee members asked about friends of the committee. And I think when we've been admitted, we are actually part of the committee. We check the standing orders. So we actually have just a right to participate just as a members, just to help my good friend engineer. But Chair, listening to Sunkuli, and I think he's right, on the issue of fair administration of justice, I think it would do good if this committee invite all the affected stakeholders. So because the claim is between the Tende and the Moyoi community, I think I want to request that you give the Moyoi community an opportunity to also come and make formal submissions, even if they don't request themselves, so that before you compile your final report, it is actually captured. But also on Sunkuli's point, Chair, maybe he should know that the wisdom behind forming the Petitions Committee was to listen to the members of public in any case where they think that they have a rightful claim and they have not been heard. And this is a house of the people, including where court rulings are against them and they feel that they have not been fully heard. So coming to this committee and saying that the court has ruled competent jurisdiction, this committee has a right to hear because we represent the people, and that is actually the wisdom of forming this committee. So coming here to say that, the court has made a decision, there's nothing we're discussing, is actually out of order. But Chair, there are very many issues that have not been, and allow me to say that, the National Lands Commission is cutting corners. Your questions were very specific. The first question, the letters that you sent to the Moyoi community, who? Give us the name of the institution or the person who received them. And if you don't have them, you tell us that this is exactly what you did. Don't tell us generally what the commission does and things like that. Number two, when you actually send a letter and people fail to appear, what are the options of you summoning? What are the options that you have at your disposal in terms of service and even summoning? Did you explore that? That is number one. Number two, was there, and I think that was asked, by the Vice Chair, which is a question you've not answered. On the 20,000 acre piece of land that was unoccupied, was it your finding that there was a 20,000 acre piece of land that was unoccupied? Based on the documents that were presented, based on your visits to the ground, and based on all the other things that maybe you might have had access to. And that really requires a specific answer. But Chair, to help you, even as you will be retreating to do your conclusion now with your own committee, after you've listened to all this. I want to enable also this committee know who exactly are the people around there. Can we, because we have the National Land Commission and we have the Ministry of Lands, I want to ask the committee to request that the list of owners of land on the disputed parcel of land, the Moyoi, everyone else, every single person who owns a title, so that everyone will get, because the next time you'll invite the Moyoi here, and then maybe someone else will say, I am also a stakeholder and I was not invited. And we'll be going round and round and round. So since here, and I request the Chair that you rule that the Ministry of Lands do provide us with a full list of adjudication. Who owns land on this disputed land as we speak? Because that, I think, will answer some of your questions. That will answer some of your very critical questions that actually are here. So that even as you listen to people beyond the ones who are in this room and the ones you want to invite, can the Land Commission and the Ministry of Lands provide us with a full list, complete list, including the ones who own a quarter acre of the whole list?
To know that, to be sure that the 10 people had got this land. Number two, what were the irregularities which made...
Which I think that can do that. Is there a possibility that NLC can reconvene this process either by waiting for a request by the two previous petitioners or on its own volition? Now, my information is this. Constitutionally, under Article 252, the Commission has this power that it may conduct, if you read Section 1, it's of Article 1A, may conduct investigation on its own initiative. I think it is in good spirit for the Commission to take initiative based on the court decision and reconvene this hearing to the extent that all the processes, including inviting both parties, are strictly followed. And I think that the petitioner was in good spirit to be able to request for that. So that is something that I just want to inform, because the Commission is almost running away from the fact that it can take over this and reconvene based on the fact that the court has quashed it.
Well, we take notice that the Commission is currently not properly constituted. But that does not mean that you cannot grant the prayer as requested by the petition, isn't it? Yes, Honorable Sonkoli.
Sorry, sometimes I speak like a lawyer. And in terms of hierarchy, of course, the NLC is down, the High Court is up. So beyond the High Court is the Court of Appeal and the Supreme Court. And we go upwards, we don't go downwards. So if the Honorable Member would advise his people to go upwards, not downwards.
Chairman.
Yes.
Chairman.
Yes, Marius.
Chairman, the petition is before your committee.
Mm-hmm.
So, can you guide these people properly?
We will make recommendations.
Yes.
Honorable
So,
Marius.
don't get direction from Honorable Sunkuri. And he serves in a committee. I also serve in committees. I serve in the Committee of Lands. When a petition comes to the Committee of Lands, it's the chairman to make the determination. Thank you, Chair.
Yeah, the Honorable Sunkuli has displayed the tendency of acting like the chair. Yes. But let him wait for what the committee will decide. But let us now hear the Honorable Kitayama. Yeah. PS, did you want to say something?
I wanted to say something, Chair, because we are trying to look for a solution. But allow this community who had gone to the land and they were farming the land. Some of them are also from Kuria, farming the land. But we understood that report that a portion of 1,500 acres has been given to the Christians. When that consent was going to be implemented, Then there was a dispute on where the 1,500 starts, and that's where the fights happened. We again sat, Honorable Chair, with the two communities, brokered a mediation. I went to the ground together with Honorable Sunguli and other leaders to now, the farm itself, to meet the two parties, and mediated to the effect that they will surrender the 1,500 acres, government will buy another 1,500 acres to solve the two communities that were fighting there. That will solve the issue of the dispute that was there between the Kipsigis and on this matter. Then now, Mheshimiwa Robi came and said, there is another community left out. The government should have also sat and see how we can solve this matter. And that was the discussion that we are beginning to have. Now, this is now an historical issue that has been determined by National Land Commission, which the National Land Commission has confirmed that the State Department did not participate because they did not present their documentation to it. Nonetheless, a decision was made by the National Land Commission, which now the Angata farmers and other parties who had been given their titles went to court to challenge and successfully challenged this decision of the National Land Commission. The options that we have is to appeal that decision, which now will also give us, even if that decision was to be ruled in favor of the tender community, then we have a whole population that is sitting there again that needs to be sorted because they are also getting. So we have to look at it in how do we solve this problem without posing also another problem. And that's why, as a PS for lands, I have to give the factual position so that the committee might be able to make an informed decision, which I would propose that even as this petition is listened to, Honorable Chair, it is important to note that there is no unallocated land in Moyo education section. The claim for 20,000 by the tender community for the 20,000 acres is based on an agreement that they bought this land from the Syria community in 1949 or thereabout. And their interest ought to have been noted when the adjudication process was ongoing. I don't know why it was never considered or it was ignored at that particular time, because we wouldn't be here. So that has prompted now the tender community to petition Parliament, because after the initial decision was made, then again we have to petition. So it's either we start it afresh as a new filing of an historical injustice, which is processed now by the National Land Commission, but still again, noting that there are also titles that are being processed there, which will also be part of the historical injustice case. So I think we should be, to me, we should be trying to see how do we find a solution to settle all these cases. Because the danger of the direction that we might take is we might get into a gridlock, where whatever decision that is made, if you make a decision in favor of the tender, then we have another problem. We make a decision that we uphold the whole decision, then what happens to these other cases? So I think we need to find how we can deal with that matter on the chair, with those facts on the table.
Yeah, so the Honorable Chairman.
Thank you, Chair. Chair, we've been sitting here, this is what, 3 hours? I want to appreciate your committee, Chair, that you have given very good guidance, and the submissions here have been very helpful and also updating in the manner that they have come out. Chair, I want to appreciate the PS, especially the last part of his submission, because that is exactly the position that the tender community have, the Korean people have. I also want to appreciate the NLC. You are very good officers. You've done very well. It's so much. I saw the release. I don't know how many there were. It was in the thousands, I think, of the cases that we listened to. And there were very few that were allowed. Many of them were not allowed. That means, and it can only mean, Chair, that this NLC is doing its job. They did take their time. Chair, I want to submit that I've been involved in this matter since 2002. This matter started off immediately. You have seen somewhere 2001, some record, something 2001 that the PS alluded to. Immediately after that realization that we have, our land has been taken over unfairly. I started off, I was young that time. The only thing I could do is support the Wazes to prosecute this matter through any other means. When the Ndungu report, the commission was up, we appeared there. When Akimumi was doing his report, we read the Akimumi report, we appeared there. TJRC, we appeared there. When 2010 Constitution happened, Chair, we saw another avenue, an avenue to seek justice for our people who otherwise wouldn't get justice because there's something called power, and there's something called wealth, and there's something called positions, and there's something called advantage. There's no way our people are going to get any justice outside of NLC. There is no way. And Chair, I want to submit, still, there's no way that the Korean community is going to get justice outside of NLC in the setup of things. So, Chair, allow me to run us through a few points. Chair, I want us to remove the mob justice that is going on currently. That a specific piece of land, which is 20,000 acres, specifically bought by a community, through a government, using legal channels, specific piece of land, is now a subject of a tribal connotations. You will hear somebody seated in Narok saying the Korea, there's one in Big Kitayama taking our land. It's not our land. It is a specific piece of land, 20,000 acres, duly bought by a government through a process that can be verified. Records are there. So, Chair, point number one, the Munyonge and Haki are descendants of the original Korea who occupied this land through purchase. Historically, it is our land. Since 1660, 1750 thereabout, the Syrian Maasai come, we fight, we had a big fight, and I want to tell this Honorable Committee Chair, the Syrian Maasai are very brave. The first time they showed up in 1750 thereabout, they chased the Korea people. It was a big fight. They know. They're seated here with us. My friend Oleseme will tell you what I'm saying is true. The Maasai drove us out of our land. It is true. We were defeated and expelled into Tanganyika at that time. But Chair, the resilience of the Korea people. You know, when we migrated from Misri, which is now present day Egypt, I would imagine, the last point where the Korea people settled is a place called Ugutura. And that is why, Chair, and I'll tell you, and I know you, all of us know we come from communities. Chair, there is a point of reference of every community that they feel that is where they are originally, their gods are. Every community has some place that is special. That is why this fight could not just go away just because the Syria came and they actually overpowered the Korea people in that 1750s there. They had been removed from Laikipia. We all know this. So, Chair, the Korea people sit around 70 or 90 years later. They regroup and they came back. They fought. The Maasai are here, the Syria are here, they know, and we repulsed them back and took off our original Utura, which, and you want to ask yourself, why did we go beyond there? This committee needs to just find out, why is it that the Korea people are not even moving beyond that? There is a reason. That is why it's a historical injustice. After that, the war continued. The colonial masters at the time, the colonial government, they got tired of this one. Because all the time we are fighting and all this, and the correspondence are and they make it a community issue. And Chair, this is not a community issue. This is not a Masai land issue. It is a specific piece of land with clear boundary beacons and demarcations that are there, and you can go and find it. Chair, your committee has just been told that the adjudication that happened involved 60,174 acres. Chair, 20,000 acres was not available for adjudication. It had already been bought, paid for by the Kuria people, and they were occupying it. So there is no way anybody can claim that suddenly it is part of these 60,000 acres, and so how did the Kuria people discover that they are part of this state? Because one, they are ignorant. I mean, we are talking about those ages back there. So they discover when they see the Ministry of Lands doing some measurements. That's when they discover, oh, there's something going on. When they ask what's going on, they say, oh, there's an adjudication going on. So Mr. Chacha, and the records are there, writes a letter to Waziri Mwamunga at the time. Records should be clear. You go to the records, you'll find the Waziri, the Honorable Mwamunga, Eliud Mwamunga, received our complaint, written by Mr. Chacha somebody, it is there. But it was ignored. Why? Powerful people who are interested in this piece of land just ignored it. So there was a letter asking that no, we need to be included. Fast forward, Chair, 1985, thereabout. That's when all that is happening now. 1989, the PC Nyanza, no, Rift Valley, sorry, Mr. Yusuf Haji, and God rest his soul, is no longer with us, comes to Longorian, and he calls a big gathering. That is why when people here saying that they don't even know, you start wondering, but how does government work? It works through barazas also. You know, it does work through barazas. So the PC Yusuf Haji calls a baraza, shows up in Longorian, where so many of the people seated here were present, and he gives the Kuria people 3 days to move. 3 days. Immediately after 3 days were lapsed, there was a contingent of the most heavily armed GSU and any other government force you can imagine descended on this land and evicted the Kuria people in the manner that is recorded in the Akiwome report. Crops were slashed, burnt, houses were burnt, our women were raped, children were harassed, people were killed. And these are people, real people. Our graves was, it was a mayhem.
Sorry.
Chair, I must finish.
Kidogo.
Yes, Chair.
Before you finish. Bona Piers, when did you say the adjudication was done? Which year?
Chair, the application was declared on 8th November. That's when it started.
And finally registered in
2001.
2001. Yes. So the process began in 1979. 1976. And when were they evicted?
1989, Chair.
1989.
Yes.
Continue.
So, our people get evicted in the manner that I have just prescribed. But then, Chair, everybody here has avoided the fact that this land, this is a purchase. Despite it being historically our land, for purposes of peace, and the Kuria people have always done that. Even now, if you listen to the peers, you'll discover that our people have even bent forward even further. And I want to thank the NLC because the determination of NLC actually sits it. It was very difficult for us as leaders, Mheshimiwa Robi and myself, to actually convince the Kuria people that, look, let's settle. Because so many people have died. You know, Chair, those that are claiming that the place is fully occupied, including Mheshimiwa Sunkuli here, who sits on that land, is unable to even go there. He cannot go there. Because when he shows up there, he finds people, original owners of the land, on the land. He cannot access. But on records, and I really like the way ministry likes records. It is good and convenient to have records to oppress, but it's so convenient when a people are asking for their rights, they are told bring records. And these are people who have no, historically they do not have the who is who in government to protect them. So Chair, how did the money get, the cows get distributed? Because this is a purchase. There were 3 communities that received payment in lieu of this land so that the matter can be settled. The Puko Masai, whom we do not border, and we do not have any claim with at all, they received 1,189 heads of cattle. And the person who received these cows was a chief at the time. I think it was a paramount chief or senior chief or something. He's I was then known as Ole Ntutu. Records are there. I'm sure his family is aware. They know that Ole Ntutu received cows in payment of this land on behalf of the Purko Masai, because I think the Muzungu was imagining that they need to bring them on board. The Moitanic received 1,188 head of cattle, and the person who received on their behalf is a gentleman called Ole Nkoidila. The Muzungu could have written that. Maybe locally he's known as Ngwetera. No, that is the Syrian elder. The Moitanic elder was Olegaga, an elder, who received 1,189 heads of cattle. The Syria elder, Ole Nkoida, received 1,189. And 88, sorry. That is the true record as found in the records of the Muzungu. This is a court. And then the court took 435 cows as court fees. And then they sealed this matter. And according to the records of the colonial people, the area was peaceful. And that was in 1955. 29th June 1955. The letter that has been written by the then DC Narok and the then DC Kisi, the then DC Tarime, and all those that were there at the time, they did assent that now the matter has been sorted. And believe me, Chair, since 1955, that area was peaceful until 1989. Anybody can calculate that period. A DC shows up, a PC shows up, and then he gives the Kuria people 3 days to move out of their land. And then they do exactly what the Honorable Sunkulit is saying. They push the people of Kuria from their land, and I want to thank the Honorable Matthias Robi. The Constitution does not spell out that a Kuria can only own land in Migori. Such abuse of responsibility should not be allowed. The Honorable Sunkuli here has been perpetuating that narrative that the courier should just move to Migori. Watu wa Migori waende, watu wa Migori waende. And that is what the late Yusuf Haji, and I say again, may God rest his soul in peace. You will sit and listen because we listened to you. Yes, it is. That's exactly what you've been doing. You know, yeah?
There's nothing out of order.
Thank you, Chair. So, let me finish. Chair, why would a government go against its own settlement arrangement? The colonial government was a government. We were paying taxes, everybody was abiding to it. 1989, we had a government that preferred to evict in an xenophobic manner, to evict our people. And that is okay. The court findings and rulings of the colonial courts are now being told that they should not be considered, but at the same breath, we should listen to the court proceedings of the time, of the day. Chair, court is court. Court did a determination, gave us our land when we paid for it and there was peace. Government came, disturbed the peace, evicted our people, and then they have been using the court system, the justice system, using power to deny our people rights. So, Chair, as I conclude, what did the courts say? The recent court ruling. It never said that the National Land Commission was wrong. It said there was no hearing before them. How? Because, Chair, apparently there's a certain prescribed form that NLC should have given Munyonge and Ahaki to fill. So in absence of that form, either it was not filled or either it was not presented to court. The courts found that there was no hearing before the NLC.
What is that form about?
They will tell us. There is some form that petitioners, when they appear before them, they must fill so that their case is now admitted properly. That is number one. Number two.
Is that factual, NLC?
Yes, there's normally a form which is filled, but I'm yet to confirm if they filled.
So before the regulations were passed in 2017, there were forms that had been prepared, but because of the Statutory Instruments Act requirement of having our regulations passed by Parliament, we had now to formalize the process, but unfortunately Parliament did not pass the regulations on account of public participation and the fact that we introduced the regulations outside the timelines of Parliament. So that's a fact that probably the court did not know. And unfortunately, and I know Honorable Nyamita raised the issue of us appealing the case. But being a quasi-judicial body, we cannot appeal our own decisions. Parties are the ones who are supposed to appeal, and there are court precedents on that. Thank you, Chair.
Thank you, Chair.
Chair, just before they proceed, did NLC advise the parties that since you cannot appeal your own determination, ahead and appeal? Because remember, this was your work. Thank you.
NLC?
Honorable Chair, maybe you can allow me to ask the head of HLI to respond to that.
Thank you, Chair. Yes, after the court decision, the parties reached out to us and we guided them on the next steps to take. And I think maybe they did opt for that. The next steps really was naturally going to the Court of Appeal. And probably there's a philosophy that informed their decision to come to this honorable committee. Thank you, Chair.
Thank you, Chair. Chair, that was the first technicality. Chair, I want you to notice that the Kuria people were awarded this land properly by the NLC. But then the courts found a technicality, and I want you to note the word technicality. There are people can be dispossessed of their land. There are people can be killed every day, including today probably. And new money has just come in, and fresh people are very busy buying this land and killing our people. Technicality. The second technicality, Chair, is that the courts found that NLC did not hear all parties, because at least there was a party before the courts complaining. And I want to thank the Honorable Nyamita, the Honorable Senator Eddie Okech, who said, look, if we don't find exactly who we are dealing with, tomorrow somebody else will again make us go back this process, and yet it is concluded. So, Chair, even your committee, if you don't rule that we totally get the persons who are registered on that land, all of them, we know these are the people registered on that land, and then these are the claimants, so that we know who we are dealing with. Then we invite everybody, so that tomorrow they don't.
That indeed they had invited the people who are now settled on that piece of land. They were unable. So it cannot be said that the people did not attend court.
Yeah, and that is what I'm saying, Chair. I agree with you. They are saying they will prove. So I do not know why they didn't prove then, but they are saying they are able to demonstrate. But Chair, let me just finalize by saying this. The Chair, we are looking for a solution. And I really like the line of guidance by the PS. PS, you have a very good opportunity here. A very, very unique opportunity. It is true that that land has titles. Our people understand that. Our people understand that fully. Actually, they are pained, they understand it. But they have said, how many more of our children need to die? The Korean people are not there. Those that are there are few, they are living in fear. Those that hold titles are not there, they are absentee, like my good friend here. They cannot access, they cannot exploit, they cannot use the land. New money has come, them, they have force of law. They are the ones, Chair, coming with GSU and killing our people and chasing them away, shooting them like chicken. PS, you have an opportunity. Look at the demarcation of that, the description of the land. It is so clear. Beacon 17, straight line, Butura, Sinendet, what, River Migori, so clear, specific, 20,000 pieces of land. PS find it that it was wrong for a land that already was purchased and is clearly not available for adjudication to be subjected to adjudication. And then when the people discover that it is been done as such, they complain, they are ignored. And you know government can ignore. PS, you know that. Government can ignore. So Chair, I'm just saying, the PS has a very good opportunity. First of all, NLC. If it pleases you, and it pleases you before God, find rest for these people who are dying every day. Please note, and please note, people will continue dying. You know, the solution to this problem is not flashing title deeds. That is not a solution, and I want you guys to listen to me properly. The Muzungu tried it. He resorted to settlement. Previous governments have looked at it favorably and have not interfered. Please find, there is a reason why NLC was created. To serve the weak. To serve the weak. Not to serve the rich and affluent who can purchase or forcefully enter and register and therefore have records. Please, NLC, if it will please you, readmit this again. Give it justice in the manner that we conducted our, precedents. When Supreme Court nullified the presidential elections, we did our 2022 elections using the guidelines of the Supreme Court ruling. Find the court ruling and readmit this matter, listen to it again fairly. I am not saying you just take the land and give to the poor people, because when you're making the determination, I was not even a member of parliament. Meaning, I have no influence over you, but you have influence over rights. You have influence over wisdom. You have influence over fairness. And God has given you that. I know you will be interfered with. I am sure you will be interfered with. Please, listen to God more. And you see, you did a very wise thing. There's something called Solomonic ruling chair. NLC said, give back the tender community their land and integrate with those that are there. For example, if the Honorable Sunkuli has 3,000 acres, and the poor Kuria there has nothing. One example. Another example, Chair. No, let me finish.
Now that you've been mentioned,
yes,
I think it is only right if we give the Honorable Sunkuli a chance.
Please proceed.
Actually, Mr. Chairman, I have been mentioned about 4 times, and our orders, certain orders are very clear, that when you want to discuss the conduct of another man in Parliament, you have to have a substantive motion. And I do not know why it was really allowed, because as emotive as this is, the honorable member cannot come and say that I have 3,000 acres. Mr. Chairman, I want to say here, I don't. And I hope that when you are retreating to make a decision, that Honorable Kitayama should not be sitting in that committee, because I can see that he is going to sway the thinking of this committee in a direction that is going to be traversing justice. We are creating here a problem which is not existing on the ground. And that is why I'm insisting, when you come to hear us, please come to the ground, so that you stop listening to bedtime stories of insecurity, of other people who are suffering and dying. Everywhere people are dying of different things. Mrs. Chairman, I take great exception of this thing.
Thank you, Chair.
Thank you, Honorable
Chair, you just heard that no one is dying there. I don't understand how we've been burying people every day and a whole member of parliament can say nobody's dying.
I request that Honorable Kitayama,
I will not go back to that.
You based on your conclusion.
I will not go back to that.
I wish to bring to your attention that in a few minutes another committee is coming in here, and so we are supposed to finish so that you make progress.
Chair, I have actually concluded by saying that the PS can do this committee good and this country good by just being fair. There are people who are selling these pieces of land. So we did ask the PS in that discussion, because the head of state did call us, me and Mheshimiwa, and asked us, why don't you convene a meeting and do a win-win solution around this matter? I said, yeah, because since there are people there who are already willing to sell, and we'll be dealing with those that are selling, not those that are shaking their heads. Because if you're not selling, there's no problem. There are new people buying even today as we speak, there are transactions going on. Then we'll be able to have a solution that then settles everybody around there.
Okay.
So Chair, I want to submit, and I leave it to your honorable chair committee to make a fair determination so that we can solve this matter once and for all to avoid further deaths. Thank you, Chair.
Thank you. So, honorable members, I wish to thank everyone for showing up. Thank you, PS, for your patience. You had earlier on mentioned to me that you are supposed to leave to Nakuru County for an assignment. Thank you, National Lands Commission. Thank you, members of the committee and friends of the committee, and even our friends from Moyoi who came to listen. This committee is not done with this issue. Listening to the conversations here and the submissions made by honorable members, there is need to listen more to other stakeholders, and for that reason, I would wish to request that the honorable members of the committee be left behind so that we can quickly decide on something. But before that, the honorable PS, the honorable PS, is it possible, now that you are the custodian of government records and especially master's land, are you able to provide to this committee the list of the landowners in the adjudication section that is in question?
Yes, Chair. The record for the education section is available. However, it is the entire education section because the claim on the 20,000 had not been demarcated. So it is the entire 60,000
okay.
that you have the education section.
So is it possible to restrict ourselves to the 20,000?
How do you there is a map, it's very clear. And you have the documents. The Honorable Sunkul, if you don't have it, you should furnish us.
When we have the beacons,
Beacon 17, blah, 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 it's clear. That's the justice.
Kidogo, yes, Honorable Eddie.
Chair, on that issue, I really appreciate the fact that you're narrowing that, because it should matter to this committee that a constitutional body like NLC, whichever process they did, found that that 20 acres of land was worth awarding to the Tende community. I think it's possible to narrow down on that. And Chair, this is why I invite you, constitutional rules exist that this committee, despite the fact that the court has ruled on that, you are an equivalent court on this matter. If you read Article 125 of the Constitution, you are actually an equivalent court to that. So that if an LC was, the decision to award these 20 acres was determined based on a technicality, then I invite you, Chair, to exercise judicial authority under 159. 159 says, judicial authority is derived from the people and vests and shall be exercised by the courts and tribunals established by or under this constitution, which you established under 125. And it says that that authority will be on the principle, if you read 2D, that justice shall be administered without undue regard to procedural technicalities. Chair, this is a procedural technicality on the process with which NLC reached to awarding the Tende community. And I think that would have been a misnomer in High Court. I have not causing doubt that I respect the High Court, but I think that now that you are hearing all sides, you can narrow down on that just specific vision of NLC and focus on that, and then make a determination as a committee.
Now that the petitioner, on behalf of the Tende community, says that there is a map that exists. So when they claim the 20,000 acres, he argues that there is a map. Can the petitioner share with the
Chair, but Chair, if I may, the PS in this submission did indicate that there is no land that is unoccupied, that it is all allocated and titled. That's what he said. So all we are asking, if it is titled, it has a name. So on the 20,000, we are not talking about the big land. The PS has admitted in this forum and said that that particular parcel of land is allocated and titled. It's on our record here in answer. So the particular parcel of land that is allocated and titled, let's have the full list of the people who have the titles, so that as you are determining, you know who to invite, so that no one is left in the spirit of fair administration of justice.
Well, the bone of contention is not on the entire piece of land. The PS is correct when he says the land is already adjudicated and there are title deeds to that effect. The issue is on the 20,000 piece of land that the Tende community are claiming. can we have a list of the people settled there who are now owners? Can we have that list, Bwana PS? Then that will make our work quite easy. So, and Honorable Eddie, what is it?
Chair, constitutionally, the PS have got no authority to determine that. That's the fundamental reason why NLC was formed. The CS can only be able to execute or implement what the NLC has determined. And if not been for this court decision, the CS will take action based on NLC. And NLC has determined that matter.
Honorable Eddie, you know we are looking for information. And the information that we are looking for is in the custody of the PS, not NLC. We have not yet determined, the issue is not yet determined. What we are looking for is the information on who is settled there for the purposes of summoning. How else do we get to know who are settled there except if the PS provides a list of the people?
Chair, and that's why Honorable Drama is saying that powerful people, if you do not allow for independent commissions to take over, powerful people like the PS and the bureaucracy will not allow you to get that document. And that's why it's important that PS NLC.
Are you insinuating that the PS is not powerful and is here telling us
he is powerful and he can be able to block that information? No. That's why NLC exists.
Mr. Chairman, can I ask a question?
No.
Please, Mr. Chairman. I want to ask Mr. Chairman.
Yes, Honorable Sukuli.
I think if it is determinable, then I think your question is correct. Because I think what I would also like to know is if I can be able to know which 20,000 acres is being referred to, so that if I can get through the committee a clear message of where the 20,000 is located. But secondly, now that I know you are going to invite the other side, can we also have a full list of the people who are claiming that land?
That is going to be made available. That is available, Chair.
We can know where they are getting their historical.
That is available, Chair. And they will take them to the people who are killed, the graves that are there.
We don't know. There are so many graves in this world.
Now, Honorable Kitayama, I do not want you to address the Honorable Sunkuli. You should address the Honorable Chair. And once you've been given a chance. So let us agree that the Honorable PS will submit to this committee the list of the people living in the 20-acre piece of land as claimed by the petitioner. Yeah, and then let's also agree that the petitioner will also submit the list of the people claiming that piece of land for the purposes of.
In addition,
yes, Honorable Kandie.
In addition to that, Chair, I
Yes.
think also it is only fair if we, as a committee, if we visited the area, because according to everybody, we don't know the situation on the ground, because already Sunguli is saying that it is prudent for us to maybe visit the area and see the whole area.
It is for that reason that I was saying that the honorable member be left behind.
But my friend should also walk out.
Who?
Maybe for clarity.
The Honorable Kitayama is a member of this committee and will not be sent out by a friend of the committee. He is rightfully before the committee, and the standing orders are very clear on his conduct should he have an interest.
But your decisions will be impugned if the interested party.
Don't preempt the decisions of the committee, Honorable Sukuli. So I think having said that, we can. Yes, Honorable.
Do you want the list as at current owners because or as at the adjudication section time? Because those are two different things. Because some of their titles might have moved to third parties for parties. Do you want the list now? Do you want the searches as at now or as at adjudication time?
I think both would be.
You want the history?
Yes.
And then Chair, timelines.
And then Chair,
for submission.
We will also need them up so that we can be able to superimpose because we don't have the 20,000.
The petitioner will share them up.
Let me see.
Timelines, yes.
Chair, maybe in 3 weeks? Because we need surveyors to go to to identify the beacons of where the 12,000 begins and ends. Then now we can retrieve.
I think 3 weeks is sufficient. So thank you all. Thank you, PS. Thank you, National Lands Commission. Thank you, honorable members. Now the meeting is now adjourned until tomorrow. The time will be communicated. Honorable members of the committee, please be left behind.